Module 3, the topic, the liability that you as a server can be accountable for. Information to be covered in this module. Number 1, Dram shop lawsuits. Number 2, the potential legal consequences of overservice. Number 3, what you can be sued for. Number 4, consequences for serving an intoxicated individual. Number 5, consequences for serving a minor. Number 6, who can sue you? Number 7, damages you might have to pay. Number 8, criminal liability. Number 9, strategies for protecting yourself and your employer from any kind of liability. Number 10, using a logbook. And number 11, an alcohol serving policy. It is important for you to understand that there's more to serving or selling alcohol than most realize. This module will help you in your serving-selling decisions. If you serve or sell alcohol to an intoxicated person, you could be held accountable in the court of law stemming from the Dram Shop Act. Dram shop liability refers to the body of law governing the liability of bars, liquor stores, and other establishments that serve or sell alcoholic beverages. Dram shop laws establish the liability of establishments from the sale of alcohol to visibly intoxicated persons or minors who, as a result of being sold or served alcohol, cause death or injury to third parties through alcohol-related car crashes and other accidents. These laws were enacted in order to protect the general public from the possible hazards of serving or selling alcohol to minors and intoxicated patrons. Let me break it down for you. There are 3 parties in a dram shop lawsuit. The first party is the drinking party, your customer. The second party is the serving or selling party, you and your establishment. The third party is the person or property outside of the alcohol transaction, the victim. For example, Mrs. Jones comes into your establishment and you serve her alcohol until she becomes intoxicated. She leaves and you do nothing to assist her in finding a safe way home. Mrs. Jones crashes her car into Mr. Smith's car and hurts him. Mr. Smith is now able to sue Mrs. Jones, you for serving Mrs. Jones, as well as the establishment that you work at, and he will probably win. Here's a quick trip to law school for you. A tortfeasor, a tort is a civil wrong, as a crime is a criminal wrong. The most likely civil claim that will be brought against you is negligence. This tort requires 4 elements. One is a duty to another. This is created by common law. Common law is decided as the common to the area of where you reside that if you served alcohol to someone to the point of visible or apparent intoxication, you should get this person to safety. Yeah, you call them a cab, you call their friend, their spouse, or they just sit there until they get sober. Remember, if somebody's intoxicated in your establishment, not causing a problem, purchasing, possessing, or consuming alcohol, they're welcome to stay. Number 2, was there a breach of this duty? Did the server of the alcohol do nothing to stop that person from driving or walking away? Number 3, proximate cause. Was it reasonably foreseeable that the person who was intoxicated might have an accident while driving or walking? Number 4, damages. This includes the intangibles such as pain and suffering, loss of consortium, loss of lifestyle, and emotional distress, as well as tangible losses such as medical bills, lost wages, and damage to property. All of those involved in the alcohol transaction can be named in the lawsuit. The manager, the host, the hostess, the valet, the attendant, the bouncer, etc. will all be named in the lawsuit. A general rule of plaintiff's attorneys is to sue every person or entity even remotely involved in the transaction and let the court sort it out. In order to find a person or entity liable, a jury must only think that you are negligent by a preponderance of the evidence. Generally, this means if a jury believes there's a 51% chance or better that negligence exists, they can find you liable. This is much lower than a standard in a criminal case of beyond a reasonable doubt. One law journal reports that 80% of these lawsuits will be settled out of court for $100,000 or more. The cases have multiplied by 300% in recent years. What are the potential legal consequences of overserving? There are 3: administrative consequences, civil consequences, and criminal consequences. Administrative consequences. Your employer loses his license and you lose your livelihood. Civil consequences. You lose your home, your life savings, and whatever else you've accumulated. Criminal consequences. You pay a fine and go to jail. With regards to administrative actions, the Department of Revenue's Liquor Control Division may 1. Reprimand a license. 2. Proceed to revoke the license of the licensee. 3. Suspend the license for a period of not more than 3 months. 4. Will refuse to grant a renewal of license after its expiration. Or 5. Impose a civil penalty not to exceed $1,500. The civil consequences require more in-depth treatment. When looking at the civil consequences, there are a few specific questions to ask. What can I be sued for? You may be sued for violations of various Montana statutes, including MCA 16-3-301, 16-6-304, 27-1-710. You may be sued under other legal theories, including negligence and negligence per se. Who can sue me? The bar patron whom you have overserved, anyone that person injures, the survivors of deceased parties, estates of deceased parties, and guardians of incapacitated parties may sue you for violations for overservice. What types of damage might I have to pay? There is no cap on direct damages and can range into the millions of dollars. Indirect damages and punitive damages are capped at $250,000 apiece. This penalty may extend to both the server and the tavern itself. Penalties for infraction of this law may also result in other fines and fees to both the server and the tavern. What can I be sued for? In Montana, it is unlawful for any license holder employees, or other person to sell, deliver, or give away an alcoholic beverage to, 1, anyone under 21 years of age, or 2, any person actually, apparently, or obviously intoxicated. That is from MCA 16-3-301 and 4. Additionally, 1, no store manager, retail licensee, or any employee of a store manager or retail licensee may sell any alcoholic beverage or permit any alcoholic beverage to be sold to any person apparently under the influence of an alcoholic beverage. 2, no person may give an alcoholic beverage to a person apparently under the influence of alcohol. Montana Code 16-6-304. In fact, furnishing a person with an alcoholic beverage to the following persons will constitute civil liability for both the person serving and the establishment if A. The consumer was under the legal drinking age and the furnishing person knew that the consumer was underage or did not make a reasonable attempt to determine the consumer's age. B. The consumer was visibly intoxicated, or C. The furnishing person forced or coerced the consumption or told the consumer that the beverage contained no alcohol. MCA 27-1-710. In Montana, you can be held for damages if you serve or sell alcohol to someone who is visibly intoxicated. Visibly means perceptible to the eye. If a person is visibly intoxicated, you must not serve or sell them alcohol. What if the person I overserved does something other than drink and drive? If you serve someone who is visibly intoxicated and that person assaults someone else, you may be liable to the person who is assaulted. What if I serve a minor? Serving any liquor to a minor can lead to civil liability for any reasonable foreseeable act that the minor does. You could even be held liable to the minor if that minor hurts himself or herself.